First of all, it's very important when you start your revision to select and revise the core topics. This means that you should not revise everything that was covered in your course, but select the topics that are most likely going to come up in your exam. And how are you going to know that? If you have a look at your university platform, they should provide past exam papers. If you read the past exam papers, you will see what kind of questions come up on exams, and you will see which topics are usually in the problem and essay questions. These are the 6 topics that most likely are going to come up on your exams. I've seen these topics on land law exams many times, so I suggest that you revise these topics at least. Co-ownership, disputes, this means disputes about Charter Act, land registration, easements, covenants, proprietary estoppel. All these topics are very, very important for property law exams, and I suggest that you revise these topics. Today's topic will be beneficial interests in land law under Stack-and-Dowden principle. This is Stack-and-Dowden principle and beneficial interests are very commonly on land law exams, and I decided to discuss an essay question that may come up about this topic on your exam. So this is an example essay question about this topic, about beneficial interests. The principles established in Stack-and-Dowden and Jones versus Canet on acquisition of a beneficial interest in the property has introduced confusion and uncertainty for quantifying beneficial interests in a property. Critically discuss. The plan for any essay question is to, usually you start with an introduction. An introduction should give definitions of the legal concepts that the essay question is about. In this case, beneficial interests, Stack-and-Dowden principle. What are these legal concepts? You need to explain, but only in the introduction. The body paragraphs should be about arguments, and it should not be explanatory descriptive. After the introduction, you should have the thesis statement. This statement should be announcing the plan about what is the essay is going to about. What are you going to argue in the paragraphs below? The paragraphs below will be the body paragraphs, which should be divided in 2 parts. You should argue for and against this statement most of the time, or sometimes it's not as straightforward, depending on the essay question, but there are always 2 sides of the argument, and you have to provide both sides of the argument. Conclusion. In the conclusion, you need to sum up all your main arguments and answer the question asked. In the conclusion, you never provide any new arguments. All the arguments should be in the body paragraphs. So just to sum up, introductions are about definitions, providing the plan of the essay for the examiner. Then the body paragraphs are about arguments for both sides of the essay, and the conclusion is to sum up and answer the question asked. How to formulate an argument. An argument cannot be something that you think. It should be backed up with legal authorities. So you start first by explaining the relevant law that you are using as a basis of your argument, whether it's a statute or a case. Explain just the relevant facts, though. You're not supposed to put too many details of a case or a statute or whatever you're using as a basis of your argument. Just the relevant details that you are going to use to formulate an argument. Introduction. Explain briefly what happened in Stack-and-Dowden. Now we are moving to answer these questions specifically that we read in the beginning of this session. So in the introduction, for these purposes of answering this question specifically, you should explain briefly what happened in the case of Stack-and-Dowden and Jones versus Canet. But this doesn't mean that you should put all the facts and the judgment. If you do that, it can be very long. You should remember that introduction cannot be more than 10% of the total word count. So it should be just the relevant details that will be useful for your arguments below. Then explain briefly the main principles established in these two cases. So less about the facts, but more about the beneficial interest principle. And then thesis statements, you need to provide the examiner a plan, what you're going to argue in this essay. So something like this, Baroness Hale argued in Stack that the presumption of a resulting trust is not a rule of law. Due to the changing social and economic circumstances of the modern society, resulting trust could no longer be relied upon for quantifying beneficial interest in the property. Instead, the courts shall look at the parties' shared intentions, actual, inferred, or imputed, throughout the whole course of conduct, not just at the time of the acquisition of the property. The essay shall critically analyze if the principles established in Stack and Dowden and Jones versus Kennett on quantifying beneficial interest in the property is confusing and uncertain. Arguments for and against shall be presented. So what would be the arguments for and against? Well, the essay is asking you if it's confusing and uncertain. So one side of the argument would support the statement that yes, the principles are confusing and uncertain, and the other side of the argument would say the opposite, that they are not confusing. On the other hand, they are very, very clear. So you need cases or journal articles to make this argument as a basis of your argument, to argue whether it's confusing and uncertain or the opposite. Before moving to the argument, set the scene by explaining relevant concepts briefly. Explain what is a constructive trust and what is a resulting trust, because you need to use these legal concepts in your arguments, and it's important that you define them first. In the absence of an express declaration of trust, a resulting and constructive trust arises. A resulting trust is based on the presumed intention of the parties at the time the property is purchased. It considers direct financial contributions made by the parties and presumed intention of the parties at the time of the acquisition. So basically, when parties buy a property, if one party paid, let's say, 30% of the purchase price and the other party paid 70%, resulting trust would consider the percentages paid to the purchase price and determine the ownership accordingly. Whereas constructive trust does not just look at who bought the house, but also looks at other things like conduct of the parties, not just during the purchase of the property, but afterwards, like who paid the bills, who paid the mortgage, and so on. Before you move to the arguments, it would be logical to give a brief overview of the law in the area before Stack and Dowden. So just to make it more like more elaborate your arguments, before you say whether Stack and Dowden principle is clear or not clear, it would be useful to provide an overview of what was the law before. The judgment of Jones versus Kennett, there we have a great summary available on Simple Setting, and I suggest that you have a look at our case summary. In paragraph 29, Lady Hale and Lord Walker refer to the case of Petit versus Petit that explains, this 1970 case, that explained why resulting trust was being applied previously to family home. They argue that this principle is outdated and should not apply to the 21st century. So this can be a very good argument to argue whether or not resulting trust at this time is still relevant. It's no longer relevant, it's outdated, because it was actually discriminating women. Most of the times, at least back then, women were not participating in the purchase price equally, so it was mostly the male partner that was providing most of the purchase price. So it was more fair for female partners to take into consideration the whole course of conduct, but after what happened, after they bought the property rather than just who paid for the purchase price. And that's what they were talking about in Petit versus Petit. Arguments for the principles established in Stack and Jones being unclear and confusing. Start by outlining the main principles established in Stack and Dowden about quantifying beneficial ownership in a property. Make arguments as to why the principles from Stack and Dowden are clear and confusing. For example, Lady Hale listed a wide range of circumstances that would be affecting the beneficial ownership of a property. It can be argued that it raises uncertainty because there is no clear formula for quantifying the beneficial ownership. So when they were just looking at who bought the house, it was quite straightforward to determine the ownership. So if one co-owner paid 30%, then he would own 30% of the house. It was very clear. Whereas in this case, for the purpose of beneficial ownership and the way it was presented in the case of Stack and Dowden, there are a wide range of circumstances that court has to take into consideration to determine co-ownership, and that makes it unclear. There is no clear formula. So that's why it can be argued that it's unclear and confusing. Arguments for continued. It was argued that court shall look at the intention of the parties throughout the course of conduct. How far did the court go in inferring the intention of the parties? So the intention of the parties, and to what extent can the court understand what was the intention of the parties throughout the course of conduct? So it's very subjective and it's not very clear. Baroness Hale argued that arithmetical calculation of how much was paid by each is less important. She said that it would be easier to consider all contributions to the household, not just financial. And that is exactly what makes it confusing and unclear. Because if you consider only financial contributions, there is a clear formula. It can be quantified who owns what. Whereas if we are considering non-financial contributions, then what is the formula? How do we quantify the ownership? Lack of clarity makes it unclear and unpredictable for the parties to understand their rights and obligations. Arguments for. After discussing Stack and Dowden, explain the principles established in Jones and Kernet. So we already discussed Stack and Dowden, now we have to discuss Jones and Kernet. Critically analyze if the approach taken Jones and Kernet for quantifying beneficial interest is confusing and unclear. In Jones, Stack and Dowden was applied. The court argued that initial presumption of joint ownership is displaced when parties intended to own the property in unequal shares. Here you can refer to the facts of this case as well to support your argument, not just principles. Also, relevant peer-reviewed journal articles would be great to make your arguments stronger. So just to elaborate on this point, the facts of the case normally is not required for you to put in your essay. However, if the facts of the essay are relevant to the argument that you're making or would help your argument become clearer or stronger, then feel free to use it. Yes, you should refer to the facts if it's relevant to the arguments, but do not refer to the facts, do not explain the facts if it has nothing to do with the argument. Everything you say in the essay, except the introduction, has to be referring to the arguments you're making. But introduction, yes, you provide explanations there, but the explanation should be relevant to what the essay is asking you. Arguments for. It was argued that the court will regard the entire course of conduct to analyze what would be a fair distribution of the beneficial ownership, financial contributions, and many other factors such as advice or discussions at the time of the transfer, which explains parties' intentions, reasons why the property was acquired in the joint names, the purpose for which the property was acquired, how the property was financed, how the parties arranged their finances. All these factors were discussed in the case of Jones versus Kernet. So all these things makes it very unclear. So how is the court supposed to look at the advice and discussions of the parties throughout the whole course of conduct. So there are too many factors to take into consideration. Some of them are financial, some of them are not, and that's exactly what makes it unclear and confusing. It can be argued that this approach focuses on subjective state of mind of the parties throughout the entire course of event that can be often unclear. One judge may think that they intended to own the property in equal shares, and the other judge may think otherwise, because this is very subjective to interpret intentions of the parties. Critics argue that the case obscures the distinction between legal and beneficial ownership, which has been a cornerstone of property law. So this is beneficial ownership is about equity, whereas legal ownership is whatever is written in the register. So these cases are about parties disputing the ownership that was reflected by the register. So that is why critics argue that this Jones versus Kennett and Stack and Dowden obscures the distinction between legal and beneficial ownership. So it doesn't matter what the legal ownership says, beneficial ownership can be absolutely different according to these cases. Main points: it is undeniable that the departure from the traditional focus on financial contributions of the parties undermine principles of fairness and certainty in property law. Cases of Johnson, Kennett, and Stack and Dowden introduce over-reliance on subjective intentions of the parties, which has introduced uncertainty and confusion in this area of law. So this is for sure, these are the main points that you should mention. Arguments against. Although the cases introduced uncertainty, it can be argued that it was for greater good for protection of women. The point is that until recently, most of the women were not economically active. Even now, many women earn less than men due to gender pay gap in the UK, which is one of the highest in Europe. So it is unfair to women to consider only financial contributions when determining beneficial ownership. So this means that when a couple purchases a house in the UK, most of the times it's the male partner that can provide more capital for purchasing the house. And if we only consider financial contributions, that male partners will always end up with greater share, and it is unfair to women. Paragraph 24 of Jones versus Kennett is about the resulting interest being discriminatory for women and unmarried couple can be used to make an argument. Do not forget to support your arguments with case law and statutes and peer-reviewed journal articles. If you go to the online library of your university, there should be a filter that says peer-reviewed journal articles. There is a filter that says journal articles, and then there is another filter, I believe, that says peer-reviewed. So if you just select that, you should be able to see peer-reviewed journal articles about whatever topic you are researching, and make sure that you download the peer-reviewed journal articles and use them to elaborate on your arguments. Conclusion. In the conclusion, you have to sum up your main arguments and answer the question asked. After analyzing advantages and disadvantages, would you argue that Stack and Dowden and Jones versus Kennett cases have introduced uncertainty? Was it for a greater good? Yes, they have introduced uncertainty, but it can be argued that it was for a greater good to achieve gender equality. For further information, I suggest you go to Land Law study materials of simple studying and use our materials. We have notes about all the main areas of land law, very simple notes, very concise. So instead of thousands of pages in textbooks, you can read just few pages and understand everything you need to know for your exams. Example essays, very important content that we have. These are actually 2-1 and first class essays and problem questions that you can read to understand how you should structure your essays and problem questions. So it's very important that you read it. Our cases, we have case summaries of most of the important cases for land law, and not only for land law, we also have lots of other study modules for law. We have quizzes to help you practice your knowledge and flashcards. Just to give you an overview, we can help you with obviously all your assignments and exams. We are a group of content creators and tutors. We were studying law just like you, and we are successful law graduates. We achieved first class and 2-1 in our degrees, and we come from different universities of England, such as LSE, City University of London, and so on. We are not associated with these universities, but we hire their best graduates. We have ready-to-go first-class study materials on our platform for all the main areas of law, and we also provide personalized support with our tutoring services. This session that you're attending, this is a group class for revision and practice, which is free to attend, but we have one-to-one tutoring session, which is personalized to your needs, and we can help you prepare for your exams, practice legal writing, teach you how to do legal research, and so on. For courseworks in particular, we help you understand how to do the IRAC structure, issue, rule, application, and conclusion, how to do the correct and clear structure to get a high grade, how the art of argument making, which is very hard and takes time, and you really need help with that, how to do legal research and journal articles, how to use these journal articles in your arguments, and we can review and provide feedback as well for your assignments. For exams, we help you create a clear plan, and then we can help you implement and follow that plan to maximize your chances of getting a first class. We can help you practice with problem and essay questions from your past exam papers of your university. So it's tailored to your educational needs and and your course from your university. We have already helped thousands of law students get high grades. So we have over 20,000 registered customers on Simple Studying. If you want to get first class, you should join Simple Studying now. Thank you very much for your attention.